said that you can be at home in your place of incorporation or your principal place of business. And that was looked at as being the place that you had such continuous and systematic contacts as to render you essentially at home in the forum state. The reason why I think this is important, and I think it's going to play out to be important in patent litigation, is twofold. The first is that troll litigation, I think it has an effect on that because the jurisdictional choice of a troll case, a patent troll case, is very much a strategic choice. And so you hear of the term rocket dockets, you hear the fact that Eastern District of Texas or Eastern District of Virginia is a popular place to be filing troll cases or cases in general because of some favorable timing and favorable judges. This case is important to patent litigators that are defending against those because no longer can you just assume that if you represent a large foreign corporation or even a domestic corporation that you would be subject to the jurisdiction in the Eastern District of Texas. And so I think that's an important development. The second one is in my field, in pharma. The way the Hatch-Waxman Act works, as I'm sure most of you that are anywhere near that area of law know, the branded pharma company brings the case against the generic company because it's deemed to be an artificial act of infringement to file an ANDA. And as you also most likely know, that the cases are filed almost invariably New Jersey, Delaware. You guys now know a lot about those courts because that's where branded pharma has decided these cases should be held. That is changing. And it's changing because of this Daimler case. And a strong effort is underway with mixed results, but a strong effort is underway to make no longer Delaware and New Jersey the locus of these cases. And anyone who's involved in this area of law at all knows how important that could be. I don't want to talk about myself too much, but we now are defending cases in West Virginia for a company that happens to be significantly located there, Pennsylvania for another one. I've seen cases that have recently been filed in Maryland for another pharma company, in fact an Indian one, and cases are filed in North Carolina with another one. So already one of the effects is that branded pharma is realizing that there is an issue here, and these cases are now starting to scatter around the country. This is a good thing, I think, for our industry. The other thing that's happening is that where the branded pharma is not choosing to scatter the case appropriately, motions are being filed in Delaware and New Jersey to get the case dismissed because of lack of jurisdiction. Now, I did say it's mixed results, and in fact, so far the efforts in Delaware have not been particularly successful, as two cases with two different judges deciding on two different reasons why Delaware would continue to have the case kept there despite the motion and despite the existence of the Daimler case. Probably not going to go into details about the cases that are ongoing. I will say that one of them has been certified for immediate appeal to the Federal Circuit. Federal Circuit is now deciding whether or not they're going to take the case in the interim. And if they do so, then we'll probably get further direction on this area of law from the Federal Circuit soon. If they decline, that issue still will come up, but probably won't come up until the end of the case. So as you know, it takes a long time. That's Daimler. That's one of the cases I think it's important that the Supreme Court did, even though it was not a patent case. The next area I want to get involved in is two cases that were decided by the Supreme Court last year on the ability to recover attorney's fees. And what they've essentially done is change the standard. These are the two cases that were decided, I think, were definitely motivated by the existence of troll litigation. The cases are, now the prior standard, what's changed, was a body of law. The Federal Circuit interprets the provision I just showed you in the statutory provision that allows for recovery of attorney's fees, but the standard they set up was virtually impossible to meet. You had to prove not only was there an objectively baseless reason for bringing the suit, in other words, that a reasonable person would not have expected this to be a good and valid lawsuit, but you had to prove that it was brought in subjective bad faith. And not only that, but you had to prove that by clear and convincing evidence. And not only that, if you ever were able to convince a judge at the district court level that these things have been proven by clear and convincing evidence, when you go up to federal circuit on review of an award of attorney's fees, the federal circuit looks at that as de novo review. So in other words, you start all over again, and you have to convince those judges that it was objectively baseless and brought in subjective bad faith. That's the body of law that the Supreme Court looked at. As you can imagine, the ability to prove to one judge that it was clear and convincing evidence of objective and subjective bad faith, and then go up to the federal circuit and prove 2 out of the 3 judges that you were correct, and looking at a de novo review was extremely difficult, and at least in our field, the idea of getting attorney's fees in any of these cases, although I'm sure it existed, but in our field, it just was not something you even thought about. Federal circuit changed both of those rules. In the first case, in the Octane case, they addressed the first part of that, which is the only standard that you have to prove either the material inappropriate conduct, which I skipped over, or that is both brought in subjective bad faith and is objectively baseless. As you can imagine, they said no. And now they changed the standard. Instead, they're allowing the judge at the trial court level to determine what is an exceptional case, and for any reason within the judge's discretion, award of attorney's fees can be assessed against the party bringing the baseless lawsuit. And not only that, they changed the second part of the standard, which is no longer did you have to prove that by clear and convincing evidence. That's Octane Fitness against Icon Health. The other case is Highmark, and in Highmark, they address the issue of once an award of attorney's fees goes up on appeal, what's the standard of review? And that's the same question that we're going to talk about in the case that's pending before the Supreme Court that we're waiting for that, which is what level of review does the federal circuit give the decisions of the trial court? Now, it's an interesting question on this attorney's fees. It's actually going to be more interesting when we start talking about claim construction, but suffice it to say, and I don't know if it's going to affect the Supreme Court's decision in the other case, but they changed the standard of that too. And they said that instead, you're going to review that for abuse of discretion and not do a de novo review, so you don't have to start all over again. We're already seeing, even beyond troll cases, we're already seeing the application of this new standard. There's a case in Delaware between Bayer and Dow. It's their agricultural view. It's the Bayer Crop Sciences against Dow Agro that the District of Delaware applied the new standard, and they just simply said that the suit was baseless and weak, and they found that Bayer did not exercise enough due diligence before bringing the suit, and in their discretion, they awarded attorney's fees. So you are getting already changes as a result of these two cases. In the interest of time, I'm going to skip some of these slides. I had them prepared, but Limelight is a case. It deals with in the inducement of infringement or if you don't have a direct infringer. Anyone who's interested in this sounds like a horse race. I don't know. I'm not a big horse fan, but that's what it sounded like to me. Anyone who's involved in this area of this, but it's pretty narrow, doesn't have much application to my practice, but what they did in this case is essentially said, if you don't have an actual single direct infringer, one person that completed all the steps in an infringement case, if the patent involves a claim of multiple steps, then you can't have anyone inducing that infringement. It doesn't, it's hard to find an application for that outside of its kind of narrow facts, but perhaps smarter people than me can figure that out. I'm going to skip it. Another case, and this is the last of the decided cases, that's important, although also a little bit unclear, is dealing with the 112 defense of indefiniteness. The Supreme Court looked at this case and they announced a new standard. What had previously been the standard, and here's the statute, and this is a statute that says this is what gives rise to the indefinite defense to a patent infringement case. And it's been interpreted over the years as requiring a proof that the patent was insolubly ambiguous. In addition to being difficult to say, it's difficult to apply. And when you're dealing with the clear and convincing standard, it's hard. We've tried cases on indefiniteness before, and the standard is extremely difficult to meet. In Nautilus, they changed the standard. So no longer do you have to prove insolubly ambiguous. They give you a new phrase that you have to work from. And instead, the new phrase is, if the patent fails to inform with reasonable certainty those skilled in the art about the scope of the invention, then it's indefinite and invalid. So the obvious question is, what does that mean? What we know about it is this. They reversed the case, the Nautilus case. So we know it's a lower standard, but that's about it. All it says, fail to inform with reasonable certainty. When you actually litigate these cases, these are the words that you have your expert testify as to whether or not that standard's been met or not. And that's about it. And the same experts would say it was insolubly ambiguous or not. The same experts are going to say it fails to inform with reasonable certainty or not. And that is, I think, somewhat weak about the Nautilus case, that you don't really know what does it mean. We do know it's a lower standard. If we're trying the cases that we've tried before on indefiniteness, I'd probably like to use these words more than I'd like to use the words we had to use. But beyond that, whether it changes the outcome significantly is certainly debatable. They did do one thing that's interesting. In a footnote, they raised the question as to whether or not indefiniteness is decided by clear and convincing evidence or not. And unfortunately, at the end of this footnote, if you look at it, it says, we leave these questions for another day. So the answer is we don't know, but I think it is definitely giving an avenue when you're litigating these cases to suggest to the trial court to adopt a different standard. If they do that or refuse to do that, then that becomes an appellate issue, and then the Federal Circuit will either take that up as an issue and announce definitively what the standard is or not, and theoretically at that point, at some point, the Supreme Court could make and chime in on that. That's what they say, that we leave these questions for another day. If that other day ever comes at the Supreme Court level, is highly debatable. But in any event, I think it is worthwhile as a practitioner in this area to raise that issue. In the interest of time, I'm going to skip some cases and some other stuff. If I were better at technology, I'd just push a button and it would go right by. But I do want to talk about the last case, what's coming up. As you all probably know, anyone in the industry knows, there's a case pending before the Supreme Court, Teva case versus Sandoz, involving the drug Copaxone. In the industry itself, it's interesting because what's being debated is ultimately whether or not the Copaxone, which is a major branded product for Teva, is going to go generic in May or September of 2015. It's going to go to generic not in an at-risk situation, but in an authorized situation. So all we're dealing with is a debate over 4 or 5 months of market, because it's going to happen at least by September 2015. And the issue, ironically, underlying the validity of the patents at issue is an indefiniteness case. But none of that is as important as what they're going to do. What they're going to do is decide whether or not, on review at appellate level of claim construction, whether that is going to be given deference to the district court, or is that issue going to be subject of de novo review? It's always been de novo review. Federal Circuit has always said that, look, we want to have a uniform construction of a patent that doesn't apply district to district, region to region. So their argument, to the extent that they make an argument, they just declare the law, their argument has been that it's better to have a uniform and therefore a de novo review of claim construction. The Supreme Court is seriously looking at changing that. And the implications of that in patent litigation in the United States are extreme. And if you think about it, there's cases pending. The other thing that's interesting about what's going on in the Supreme Court now is there are now 7, or at least 7 cases that we're aware of that are on hold between the Federal Circuit and the Supreme Court waiting for this decision. So there's been cases that have been decided at the Federal Circuit level, have gone up on appeal, cert to the Supreme Court. The Supreme Court said, we're not even going to tell you whether we're taking that case or not until we decide Teva versus Sandoz. And what they're doing is those cases all were decided on issues involving claim construction. If they change the standard, they're going to kick back all of those cases. They're going to go back to the Federal Circuit to apply the new standard. Federal Circuit's going to have more issues and opinions to decide on cases that have already been decided at the Federal Circuit level. Some of them are pharma cases. Some of them, there's at least one case down there, deals with the claim construction of a molecule. It was even by a second filer that had a claim construction. That claim construction came out of the Southern District of Florida. There are two other cases that are ongoing in the district court level on the same drug, one in the Northern District of Georgia, which is my home, but I'm not on that case, one in the Middle District of Florida, which I am on, and all of those are at the claim construction stage. And the claim construction is dispositive, we think, on the issue of infringement. So there's a construction that the Federal Circuit has said is applicable to the Southern District case. If Teva versus Sandoz results in the change of the standard, you could have a claim construction that gets affirmed that came out of the Southern District because of the deference now that you have to give it. Northern District of Georgia has already issued a different claim construction. One's favorable to the generic side. The Middle District of Florida hadn't issued their opinion yet. You could have three different claim constructions on the same drug. All three of them are second filers. And so the chaos, if you think about it, the chaos that can ensue as a result of a change in the law, and the Supreme Court understands that that's one of the factors, but that may not be their motivating factor. They may change it notwithstanding that. But they've taken the